like first to something pop up. I would like first to start by acknowledging my positionality as a migrant to this land, and that UNSW campus is located on the unceded territory of the Bidjigal people, and to pay my respect to the elderly past, present, and emerging, and to any Indigenous colleague who is here with us today or might be listening to this recording later on YouTube. This webinar series is a collaboration with the Diplomacy Training Program, Youth for Australia, and Australian Lawyers for Human Rights, and I would like to thank them for their ongoing support of this initiative. Today, we will focus on refugee and asylum-seeking children in Australia and Australians' obligation under international law. We have two wonderful speakers to come to speak with us about this topic, but before I introduce them, I'll just say a word about housekeeping. Please keep your cameras on, but your microphones off. We ask that you post any question or comments using the chat function, and we will have a Q&A session after the two presentations. We will also be sharing some resources during the presentation at the chat function, and all of that, and all of you will receive an email later today with links to those resources and recording of today's talk. And as I said, we have two wonderful speakers lined up today. The first is Professor Mary Crock from the Sydney Centre for International Law, University of Sydney Law School. Professor Crock was awarded the inaugural NEDA medal by the National Ethnic Disability Alliances, and in 2016, she was given the Affinity Intercultural Foundation Awards for contributions for social justice and human rights. In her talk, Professor Crock will engage with the shortcomings identified by the UN Committee on the Rights of the Child and the requirements for action by all levels of governments, taking account on the essential child rights principles of the best interest of the child. Our second speaker is Rasika Jayasuriya, who is a migration policy specialist at UNICEF in Geneva. Rasika has worked with the UN Migration Network Secretaries at the International Organization for Migration in Sri Lanka and the Office for Multicultural Affairs and Citizenship at the Victorian Department of Premier and Cabinet. In her talk, she will outline issues of migration, detention, and trafficking, both areas addressed in the concluding observations for Australia that were published by the UN Committee on the Rights of the Child in 2019 from a global perspective. She will touch on ways other governments have ensured the rights of children of migrant and refugee background, and comments on the UN Special Procedure Statement on Australia's detained in Syria. So the plan for today that each speaker will speak for about 10 to 15 minutes, and then we'll have time for a Q&A session with all of you. So without further ado, Professor Crock, the floor is yours.
Right. Well, thank you very much, and thank you both to the organisers and to the participants for giving up your Thursday afternoon to come and listen to this webinar. I am Professor of Public Law at the University of Sydney, and I have done a lot of work with migrant children over the years. My focus really is in vulnerable migrant children, asylum seekers, and children with disabilities in displacement as well. What I'm proposing to do this afternoon is to, and I am very aware that some of you know more about this than I do, but in light of the need to use this as a training session for everybody, I have prepared some slides for you, and I'm also going to get the organisers to share with you a compilation of documents, or notes rather, that I have put together in conjunction with interns who have worked with me at the Sydney Centre for International Law. I hope that you might all be aware of the Australian Yearbook of International Law as a resource. As part of our public outreach work, the Sydney Centre for International Law every year has its interns work with the directors. I'm a current director, I have been for the last couple of years. What we do is we summarise all of the reports and case law relevant to Australia and international law, and that gets published every year in a series of articles in the yearbook. So the material that I'm making available to you is taken from the yearbooks for 2019, 2020, 2021, and the material for this year is still being prepared. So let me begin by sharing my slides, which will also be made available to you in due course. And I'm just going to click through them as we go so that I don't lose track of the system here. Here is the introduction that I don't need to make for you. I'm sure you'll know that the Convention on the Rights of the Child is one of the most subscribed of all the human rights conventions. There's in fact now only one state, America, that has not made itself party to it. We've got 3 optional protocols to the CRC, as we're going to call it. Australia is party to 2 of them, but not the 3rd, I understand. And Rasika, you might correct me here, but I don't think we have signed the optional protocol that allows us individuals to make complaints. Is that correct? Yes. People are nodding. Yeah. So I should declare here that I've had taken a very keen interest in the procedures for the CRC committee, as they call it, in part because I've been very involved with the Committee on the Rights of Persons with Disabilities. My slides contain a couple of slides on the CRPD, as we call it, as well. In many respects, in all respects, its procedures were modelled on the Convention on the Rights of the Child procedures. The CRPD, interestingly, had a complaints mechanism process given to it before the Committee on the Rights of the Child, which is really interesting. So again, you'll know this, the CRC is the Superhuman Rights Convention for Children. It has picked up all of the key immutable rights, human rights that have been committed, that have been acknowledged from the 1960s onwards. I guess the point I want to make here is that for those of you who are not aware of the human rights oversight mechanisms, Claire, you might want to just mute yourself because I think we can hear you. That's right. Sorry, thanks. You've now got 10 human rights conventions, and most of those, with the convention comes a committee. The CRC committee has been in operation since the 1990s. The oldest of the committees is the committee that was set up under the International Covenant on Civil and Political Rights back in the 1960s. In fact, the committees from the 1960s have been there for years, including the Committee Against Torture. The CRPD committee and the CRC committee are relative newcomers, but nevertheless, I think have become, they're pulling above their weight in the scheme of the UN system. So what you need to know for this afternoon is that those committees do 2 things. They ask the states parties to each convention to appear before them every 4 years to basically answer questions about how each state is complying with the various articles of the convention. So that's a 4-year review by the committees. I'm going to speak first to the report that was published by the CRC committee in November 2019. I'm also going to talk, however, about the CRPD committee and what they've had to say about Australia and refugee children. You will be aware that in addition to the reporting function, these human rights committees also have the ability, when states sign on to an optional protocol that allows this to work, they have the ability to review individual cases, complaints that are brought to the committee. And what's interesting is that the CRPD committee now has quite a body of jurisprudence that is coming out on children and disability. Human Rights Committee, of course, has a very long line of jurisprudence now, a great number of cases, in fact. Now, so that is what I would call the UN treaty body system. I want to draw your attention to the fact that Australia is also subject to oversight by another UN human rights body, namely the Human Rights Council, which it's a very different. I should perhaps just briefly stop and tell you what these reviews, how they operate. With the individual human rights committees, the reviews generally take, they generally go over 2 days, one afternoon and one morning. And it's quite a process where civil society, including many of the organisations that you represent, people who are attending this afternoon, information is put in by the state and by civil society. There are side events, and it's quite a big event. The Human Rights Council, on the other hand, with the Universal Periodic Review, is a much quicker, and some would say quicker and dirtier process that sees countries reviewed for about 90 minutes in all. And I think I'm going to make some comments about Australia's most recent appearance before the Human Rights Council. The last 2 appearances that we've had before that body, what has been utterly remarkable is the number of countries that have put their flag up to ask questions or to make comments about Australia, and our policies and our behaviour with respect to migrant children has been really high on the agenda of the people. Now, I realise that time marches on very quickly, so I'm going to begin by bringing your attention. You will have this to read as you go away. The last time that Australia appeared before the CRC Committee to answer for its treatment of children, we actually managed to miss one of the reporting periods. So we slipped behind. This document from the 1st of November 2019 represents observations on the 5th and 6th periodic reports of Australia. So we ended up putting in, we got permission to put our reports in both at the same time effectively for 8 years instead of 4 years. What is interesting, I think, about this is that the committee was showing for the first time a great interest in the impact of climate change on the rights of children. It made a point of endorsing the efforts of children to try to move states. This reporting period also coincided with the Royal Commission that Australia had conducted into violence, sexual violence, abuse and neglect of children in the country, and that was noted by the committee. I had the privilege of assisting that committee, that commission, Royal Commission, to look at the position of migrant children in immigration detention. I've got to say that our treatment of asylum seeker children, the default that a series of governments have taken in and putting children into immigration detention, in not excluding children from offshore processing, moving them first to Papua New Guinea, to Manus Island, and then to Nauru. It really has created, I think, a running sore. That and our treatment of young Indigenous children has been front and centre for many years. I'll just give you one quote from the committee. This is paragraph 44. of their report, the committee expressed its disapproval of the fact that, quote, the best interests of the child are not a primary consideration in asylum, refugee and migration processes, leading to children going through lengthy assessment determination proceedings. At the time of this report, there were 286 children transferred to Nauru and thousands of children before them in Australia in the legacy caseload who will not be settled in Australia and are encouraged to engage in third country migration options, leaving them in limbo for an undetermined period of time. I regret to report that really nothing much has changed, other than we can say that there are no children in closed detention as we speak. Yes, the committee called for the amendment of the Migration Act to prohibit the detention of children of their families in Australia and in regional processing countries. We did manage to get an amendment to the Migration Act, section 4AAA, which reads that a child should be only detained for the shortest possible period of time. It hasn't stopped children being detained, and it is nowhere near adequate in my view. So it is interestingly one area where there has been at least some public outrage in Australia to move those, to move the practice, if not the policies per se. Now, the second document I've given you in the compilation is the concluding observations by the Committee on the Rights of Persons with Disabilities, the CRPD committee. They reported just before the CRC committee on the 15th of October 2015. And I've given you the whole extract from that so you can look at it. But you'll notice that they took a particular interest in Article 18 of the CRPD Convention and expressed their concern about the, again, the detention of the treatment of people who are caught up in the so-called legacy caseload. These are the asylum seekers who, if they were not transferred to third countries for processing, they were subjected to a very rudimentary process in Australia that has left a lot of people languishing for a long time. They acknowledge that these are policies which create disabilities. I think that's the point to take away here. If you don't stop children from being included in offshore processing or in the suspended life that they're given in Australia, that creates disabilities. We have seen in Australia a number of children developing what's known as Resignation Syndrome, where they become literally physically paralysed because of the uncertainties in which they are being forced to live. I will just briefly mention here, and I know it's not immediately relevant to asylum seeker children, but the CRPD committee has a very interesting case from 2020 involving a young man called Ruben, who is a child with Down syndrome, and he brought a successful complaint against Australia in the way he was being treated in the educational system. That really highlights for me the fact that the Convention on the Rights of the Child makes no distinction between children who have lawful immigration status and children who do not. In fact, there are, if we had the time, there's so many other international instruments relevant to children, particularly to the education of children, that are worthy of attention here. Australia gives primary age children access to education, but not. I don't believe that they are compliant with our obligations under the CRC when it comes to asylum seeker children. Look, I've also included two other things for you, and I realise that I'm running up against my time limit here. One is the attempt that a group of human rights activists in Australia made to actually bring a complaint against Australia before the International Criminal Court, arguing that Australia's use of offshore processing, its deportation, its of asylum seekers, the circumstances in the detention centres amounted to crimes against humanity. That's a really big call, and it's interesting that the International Criminal Court, the prosecutor actually declined to take the complaint. They found that there was insufficient evidence to demonstrate that the acts were a widespread and systematic attack directed against a civilian population, which is required for crimes against humanity under the Rome Statute. And our intention to deter immigration was not enough to support that finding. So anyway, I guess the takeaway is people are trying have been trying all sorts of mechanisms to affect change. I'll finish with the Human Rights Council report on Australia from 2021. The report of the working group on the Universal Periodic Review was handed down on the 21st of June and the 9th of July 2021. And you'll be interested to know that one of the recommendations made by the council, roundly rejected by Australia. I've also given you a summary of what how Australia responded to this. But they recommended that Australia should sign or ratify the optional protocol to the Convention on the Rights of the Child. Yes. They also said that they needed to increase funding and deal with children with disabilities better than we were, and that our efforts to improve the human rights of migrants needs to be strengthened, even if there are currently no children in immigration detention. This is still a problem for Australia, and a nice point to segue to our next speaker. They also called for additional frameworks to be implemented to prevent human trafficking and slavery, including better cooperation with our regional partners. So I will leave you to have a look at how Australia responded to that. Of course, the government of the day said, nothing to see here. Migrants, refugees and asylum seekers, our policies are an essential component of border management. So there we go. I think that's enough to open the discussion.
Excellent. Thank you very much, Mary, for this very comprehensive and detailed overview of where we stand, where Australia stands in the international arena, and the numerous violations of international law that children are subject to. We have kind of a range of guests at this webinar. I will put Anne Holland, the National Child Commissioner, on the spot here and invite her to comment at the end of the second discussion paper if she wants to make any observations as to what her office is doing with respect to asylum seekers and refugee children, but that's optional. But without further ado, let's move on to our second speaker, Rasika Jayasuriya. The floor is yours, please.
Thank you, Noam. I'm just bringing up my screen here.
Yeah.
Great. Everyone can see that, I trust. Yes, thank you again. It's a real privilege for me to join you today and to be able to make a very small contribution to the fantastic work of the Diplomacy Training Program, and also to speak alongside Mary, who actually happened to be my doctoral thesis examiner, and for whose contribution to the body of knowledge on children's rights in the context of migration. We all have a lot to be grateful for. So Thank you. And also thank you to the organisers for creating what is really an invaluable space to bring children's rights into discourse about migration policy, as children affected by migration and displacement are really often overlooked at their specific needs and their rights, and particularly the unique obligations that states have towards them. So I think this is a very important space. In the interests of time, I will jump straight into some comments on the handful of areas that are picked up in the committee's concluding observations on Australia's reports in relation to asylum-seeking, refugee and migrant children, including immigration detention, guardianship, returns and trafficking. And as Noam mentioned, I'll also make a few brief comments relating to the UN Special Procedures Statement on Australians detained in Syria. But I should note that UNICEF generally doesn't address this as a migration issue per se. So on immigration detention, the CRC Committee has urged Australia to prohibit in law the detention of asylum-seeking, refugee and migrant children. In last year's Universal Periodic Review of Australia, the Australian delegation highlighted that immigration detention of children was always a last resort. But what's important to note is that the committee's guidance on the Children's Convention, provided in its joint general comments on the human rights of children in the context of migration, is very clear in its direction that the immigration detention of children, whether they are alone or with their families, is never in a child's best interests. It's a violation of their rights, and it should not be used even as a measure of last resort. I've put up just a few quotes from the general comments here. Importantly, the committee has said that the CRC's provision that detention shall be used only as a measure of last resort may apply in other contexts, such as juvenile criminal justice, but it is not applicable in immigration proceedings. And this goes back not only to the best interest principle, but also to the centrality of the principle of non-discrimination in the CRC, that migrant children should never be discriminated against on the basis of their or their parents' immigration status. So some states, like Colombia, simply don't use immigration detention for migration purposes. And others are taking active steps to end child immigration detention and scale up non-custodial alternatives to detention. So for example, in 2020, Mexico harmonized its migration and refugee laws with its general law on the rights of children and prohibited by law the arbitrary detention of children, both unaccompanied and accompanied, based on migration status. So very importantly, these legislative reforms ensured that best interest determinations are undertaken by an authority other than the Migration Authority. And they also transferred responsibility for migrant children from the National Migration Institute to the National System for the Protection of Children. So this highlights two things: the need for child protection agencies to lead on a state's fulfilment of the care needs of asylum-seeking, refugee and migrant children, and the need for these children, no matter their migration status, to be treated as children first within national child protection systems and standards. I've shared some resources on promising practices from other countries that Claire will put in the chat. And I also just wanted to highlight the last point on this slide, that to avoid the risk of detention for children, the key mechanisms are swift identification, referral to national child protection authorities, and the provision of a guardian. And I emphasise this because one of the recommendations in the concluding observations is for Australia to create an independent position for guardian for children. And we see this in countries like Germany, the Netherlands and Sweden, where independent, qualified and trained guardians are appointed for unaccompanied children throughout the migration process. And the Netherlands actually has a dedicated independent guardianship institution for unaccompanied children, which plays a critical role in providing age-appropriate and culturally sensitive information to children about their rights and the processes that they'll be involved in, and in representing the interests of the child. And this includes representing the interests of the child in returns processes and planning and preparing for return when return is the outcome. So I don't have time now to go into child-sensitive returns and reintegration, but given the recommendation in the concluding observations that Australia amend legislation to ensure respect for non-refoulement obligations, I just wanted to make a few very brief comments. So globally, UNICEF has expressed deep concern about the fortification of external borders, expedited returns procedures, maritime interceptions, pushbacks, all of those kinds of measures which we saw escalate in some contexts during the pandemic. And UNICEF is not only concerned about the children directly affected, but also the risk of normalising and legitimising pushbacks and the related child rights violations in these kinds of approaches to border management. Children and their families have the right to seek asylum and have their protection needs evaluated on an individual basis, with children's best interests being systematically assessed in returns decisions. And to identify a sustainable solution that protects the child's long-term best interests and welfare, states really need to invest in robust best interest procedures that are led by child protection actors. So, for example, in Sweden, independent best interest assessments are routinely conducted as a part of all asylum decisions and are included in all refusal and return decisions concerning both unaccompanied and accompanied children. And in Sweden, the Netherlands and the UK, state-funded legal assistance is available for children in asylum procedures, including appeals, and this is to guarantee due process, including the right to legal advice and representation, and the right to appeal a decision before an independent body. I'm sharing this slide just to highlight, some examples of what happens when children are returned in non-child sensitive ways. Not only does it increase risk of exposure to violence and the potential for attempted remigration by the same child, it also increases risks of recruitment by armed groups and also of trafficking and exploitation. Very briefly on trafficking, the concluding observations urge Australia to put in place child-sensitive mechanisms to promote reporting by child victims and survivors to ensure that victims themselves are not criminalised or re-traumatised. And we know that migrant, refugee and internally displaced children are at particular risk of being trafficked, and that states have obligations to protect children from trafficking and to ensure that special measures are in place to identify and support children who have been trafficked. The CRC provides the framework for these obligations, while other tools like UNICEF's guidelines on the protection of child victims of trafficking outline in more detail the special measures required. Special protection measures for child victims are needed because of their age and also because of the severity of the human rights violation. Like other children in the context of migration, a child victim of trafficking must be treated as a child first. But one difficulty is that trafficking cases are not always recognised as such and may be tried under national legislation that's not the most appropriate legislation, like migration laws, if they haven't, if they don't align with being the most appropriate form of legislation under which a trafficking victim should be treated. And this can deny victims the necessary legal protection and assistance to which they're entitled under international standards. And another barrier is that victims fear coming forward to law enforcement, particularly children. Migrant victims of trafficking live in fear of deportation and retaliation and are often treated like other irregular migrants. And often their right to stay and to stay in safety is conditional upon things like their cooperation with law enforcement. I've included in this slide some of the key measures from UNICEF's guidelines and also our Reimagine Justice for Children agenda, which I won't go through in detail now, but it is worth noting these recurring protective measures that we see come through all of the areas I've touched on. And they're recurring because we're talking about children first and foremost. So measures like swift identification, appointment of a guardian, safe and non-custodial accommodation, individual case assessments, access to child-sensitive procedures and information, and free legal representation. But what's really critical is that we don't create separate systems for each category of migrant child, but rather we strengthen the national child protection systems so that they have the capacity to respond to all children in need, and that we avoid very rigid definitions that may exclude vulnerable children from accessing necessary care and protection. And this also applies for the children of foreign fighters, who are also children first. While UNICEF can't comment on specific countries, it has urged states to take responsibility for children who are their citizens or born to their nationals, providing them with civil documentation and preventing them from being or becoming stateless. The failure of states to repatriate and otherwise care for these children and to leave them in camps like those in Syria without services and support based on the status, beliefs or affiliations of their families is a child rights violation under the CRC. As always, the best interests of the child must be the primary consideration. And when determining what course of action is in the child's best interests, procedural safeguards should be in place, social work professionals should be involved, and the entire situation of the child should be considered. So international legal standards pertaining to children must be applied to children of all ages and cannot be lowered. And if children are over the age of criminal responsibility and accused of criminal acts, internationally recognised standards for fair trial and juvenile justice must be applied. And throughout, children's views should be considered and be given due weight consistent with their age and development. It is usually in the best interests of these children for the process of repatriation to extended family members to be initiated as swiftly as possible, and for family unity to be promoted through the prevention of family separation, identification and care of separated children, and family tracing and reunification. So UNICEF encourages countries of origin to design and implement strategies to facilitate return of these children, ensuring that upon repatriation, they are served by existing child protection systems and their reintegration is supported without stigmatisation or discrimination. So in the interest of time, I will stop here, but I have shared some resources, as I mentioned, on each of these issues, which if you wanted to go into more detail, it's there. And there's also some examples from other countries. And of course, very, very happy to answer any questions that you may have, but I'll hand back to Noam for the moment.
Rasika, thank you very much for this very comprehensive and detailed overview of international best practices and where UNICEF stand on issues. Lots of questions coming from both your presentations. While waiting for our participants to populate the chat function with some questions, I think I just mentioned that the third optional protocol of the convention, the protocol of communication that Mary has mentioned, which Australia didn't sign up to, has resulted in a number of complaints being brought against a number of European countries about their failure to protect the rights of migrant children and refugee and asylum-seeking children. So we have decisions about against Spain and the Netherlands and France along the line of the recommendations that Rasika has mentioned that UNICEF has made, their failure to protect the rights of those children in various stages of the asylum-seeking processes, including question of reputation and against France, who failed to protect its own children citizens who are captured in Syria or living in refugee camps over there. One question, Rasika, you've mentioned that one of UNICEF recommendations is to extend and to increase the capacity of national child welfare agencies so they can cover and accommodate the needs of asylum-seeking refugee children. And I was wondering, given the failure of Australia to properly handle these children on the one hand, and the embedded racism in the current child welfare processes and agencies, how can the two meet together? If the system fails Indigenous children in Australia and is working based on an assumption, working assumption is racism, how can increasing their capacity or their jurisdiction might mitigate the failure to meet the rights and best interest of incoming children?
Yeah, thanks, Noam. That's a great question. I think across the board and definitely at the global level, we would say that it's about strengthening the whole national child protection system. So if the system's failing for Indigenous children, then obviously it needs to be strengthened to be able to respond to Indigenous to the needs of those children. But what we don't want to see is one system for Indigenous children, one system for asylum-seeking children, one system for migrants whose children have a particular status, another system for children who are identified as victims of trafficking. Basically, if we put the principle of a child as the primary thing, then there are just core rights and core needs and core vulnerabilities that are general to all children that need to be incorporated, and that should inform the whole national child protection system so that it can respond to all, and then capacity building and investment in capacity building for that system and trained up workers. But that's not to say that we don't then want to identify the specific needs and vulnerabilities of particular cohorts, which within that system, obviously you would need to have that information and those targeted responses to A, bring them into the system, and to B, then respond to their unique needs. And I think in your previous webinar, as part of this series, one of your speakers touched on this. I think Natalie touched on this, where she said, you know, there is a risk at speaking about issues at scale. And I think that is exactly this. It's within the broad system, we still need, and this is where we really lack at national and global levels, we lack disaggregated data, and particularly in migration, in the migration field. So if we don't start investing in also in disaggregated data, we won't understand the unique needs of particular cohorts. But it does. What we don't want to see is a separate system for each, and then rights attached to that. And yeah, so I know that's a bit vague, but basically it's like the same investment that's needed to build up the system to strengthen responses to vulnerable groups like Indigenous children. We need to see that also, benefiting the whole system.
Look, if I could just jump in here at the risk of naming the elephant in the room, I think one of our problems in Australia is that this has become hugely politicised, and at the moment we have a government that is not terrific with acknowledging human rights. In fact, our entire human rights mechanism in Australia has been downgraded in recent days, if you've been following that, which is a real concern. I am hoping that, and in the electoral cycle that we're in at the moment, unfortunately, the main opposition party is doing everything it can not to mention anything to do with refugees and asylum seekers. We know that there are two little Tamil girls that they are keen to give protection to, but in other respects, we have the opposition has been too timorous to say that they want to step up and do the right thing with respect to refugees in Australia, including children. So I think for me, the point is that human rights is not something you ever achieve in any country. It's something that you always have to keep battling for. And we live in very difficult times at the moment when it comes to trying to see structures for the protection of children's human rights in the migration area.
Thank you, Mary, for that. And I think, I mean, as I mentioned, Anne Hollands, the National Child Commissioner, is here with us today. I'm putting you on the spot. Feel free to log off the conversation. But I was wondering if you want to jump in and say a few words, especially after what Mary has just said about maybe the diminishing powers and authority voice that the Commissioner have these days.
Well, what can I say? It's a pretty bad time to be working in the human rights industry, let me tell you, on so many levels. So this is a fabulous webinar. Thank you very much, everybody, and for the presenters. I might, rather than comment on the sad state of human rights and the politicisation, I might just go to the child protection issues that you've been talking about, if that's all right. And just to point out that we actually don't have a national child protection system. There's no such thing. It's run by the states, and that's part of the problem. It's variable in its quality, of course. And I'll just give one example: is the fact that only 2 states have implemented what's called the National Principles for Child Safety, following the Royal Commission on Institutional Responses to Child Sexual Abuse. And I had to give evidence on this issue in Tasmania on Monday, so it's sort of on front of mind, because Tasmania now has set up its own commission of inquiry because they've had recent matters arise. But when you look at it, they never implemented the national principles, and so they've got no protective framework for how they conduct their schools, their detention centre, their out-of-home care. They've got nothing, right? And so it's like we're back way before the National Royal Commission was run. I mean, it was really pretty horrifying. So that's just a recent example. But the truth is that whether you're a First Nations child or a child that's come through from another country as an asylum seeker, how well you're helped is a matter of luck in this country, depending on where you are, depending on what kind of help you manage to find. And I suppose at a general level, what I try and argue is that that's not acceptable, that it's a matter of chance whether children get what they need. It's pretty clear that the Convention on the Rights of the Child is not applied to immigration policy. The best interests of the child principle is not applied as a primary consideration. And we see that again and again in the decisions. I mean, I have virtually no resources to do work in the immigration area, I might add. I have to rely on the Human Rights Commissioner's help for this. But the things that I have been involved with, for example, were I did investigate and advocate on the wellbeing of children in the legacy caseload group, the many children now who are still living in the precarious circumstances. Obviously, the Tamil family I've advocated on, the children deported back to New Zealand. This is an issue that the New Zealand Children's Commissioner constantly is contacting me about in despair. You know, why aren't we stopping these children being, you know, sent back to New Zealand? And then, and there are also during the COVID lockdown in India, I advocated on the issues of the bringing the children back. You might recall there was quite a bit of media about that issue, that there were kids stuck in, Australian children stuck in India, and they were being brought back by strangers on aeroplanes because families couldn't think of any other way to get them back. So, you know, there are many variations of risk to children in our environment currently, and we just don't have that framework of protection. And unfortunately, whilst human rights is having a hard time, as Mary said, when it comes to children, it's an even harder time. I mean, children, even though children are nearly a quarter of our population, they really take a back seat. Policy is designed for the concerns of adults. We saw that in COVID, and it is extremely hard to get anyone interested in children at a national level, I'm afraid.
Thank you for that honest account of where we stand at the moment. And that doesn't look good, and not least because our best practices that Rasika has described are almost a checklist of everything that we don't do down under. We have a few more minutes for some more questions. Mary, I would like to ask you about one particular group of vulnerable children that you've mentioned earlier in your presentation, which is about children with disabilities. And the practice that is exercised in Australia, where children with disabilities and some chronic illnesses and their families have been rejected for permanent visas due to being considered as a burden to Australia. And you've mentioned the CRC, you've mentioned the CRPD, and I was wondering if you have some thoughts about these practices and maybe some comparative views as to how children in similar situations and families with children with disabilities are being treated by other countries.
Yeah, oh, thank you, Noam. Look, I think this is another area where Australia really stands out as a very bad example of worst practice in the world. Many of your participants will know that there is currently another Royal Commission that is being conducted into the neglect, abuse and violence against people with disabilities in Australia through the Sydney Centre for International Law. In fact, one of the people who signed up for this helped me write this. We put together a 250-page submission on migrant children and disability to the Commission. And I can make that available to anybody who's interested. I'm actually toying with the idea of converting it into a book at some stage. But one of the things we did was we looked at the way that the health rules operate in Australia, the fact that there are no distinctions drawn between disability and illness or disease. We have a one-in, all-in migration policy, whereby if you've got a child in a family group with a disability, the disability of the child will effectively cancel all of the family. And I mean, our laws just go against the most basic principles of non-discrimination imaginable, in the sense that if you have a disability, you literally get barred, even if you are a genius who's got to bring incredible wealth and benefits to the country. if you are eligible in all other respects for migration, but you have a disability, that disability will operate to exclude you. So we are, well, a lot of people are trying very hard to shift thinking in this area. And I don't know, all I can say is that it's a work in progress, but I think at least in this hour, we've managed to at least touch on, may I just take this opportunity to acknowledge, Anne, the work of your daughter, Gemma. Gemma, in fact, is a co-author of one of my most recent book, which is Children and Young People in Asylum and Refugee Processes Towards Best Practice. So for those of you who are interested in the nitty-gritty of how Australia does and does not, actually the aim of this exercise was to try and articulate what Australia is doing and what we should be doing in the processing of children in asylum processes. So I don't know if I've answered your question there, Noam.
Yes, you did, and we'll
Very
share
good
the details
question.
of that book with all the participants of this webinar. We have a few more minutes left. Rasika, I would like to ask you a question out of the blue. If you have any knowledge about practices that European countries are currently employing with respect to children who are leaving Ukraine with or without their parents or family members.
Yeah. So sorry, I mean, UNICEF has been very, very active in the response to Ukraine, setting up a lot of what we call blue dots, basically creating reception centres at the borders of all of the surrounding countries to divert families with children or children who are arriving on their own. One of the huge concerns has been trafficking, with Ukraine having one of the highest numbers of children living in institutional care, particularly also with disabilities, and busloads of them arriving unaccompanied or with one or two kind of carers. So in terms of specific country responses, I would have to get back to you, but I could certainly share some resources later in the chat. But while I have the space, I just wanted to very quickly pick up on what one of the points that Anne had said, which was just about Australia not having a national child protection system. Yes, I'm sorry, I should have recognised that. That's sort of our global kind of statement. But I did work for a very long time in the Victorian government, and we saw that very much so, where we were working very hard to fill gaps, particularly with the inclusion of asylum-seeking children in the education system at the state level. So definitely those disparities are certainly there, and I think amplified in the Australian context. And I just wanted to highlight that at the global level, we're working very hard, I think, to elevate recognition of local level responses, and recognising and giving more recognition to the fact that many of the best practices that we see in responses to migrant and asylum-seeking and refugee children are at the local level, driven by mayors, driven by local level governments and cities. And we saw that a lot during COVID with the release of people from immigration detention, the welcoming of refugees and migrants, all of that sort of stuff. A lot of the best practices that we do see and we should be showcasing are not at the national level. So yeah, that was just something I wanted to pick up on. Thanks, Noam.
Thank you, Rasika. Mary, do you have any last comment or word that you would like to add?
Well, I just put a comment in.
Besides the fact that we all agree that Rasika rocks. Yep.
I just put a comment in the chat. I think Rasika is fantastic. I'm very proud of her. She writes as well as she presents as well too. Look, what we said before, I think we're moving into a period with a new government, possibly a change of government. And I think that represents opportunity for us, particularly if we end up with shall I say, a more teal-coloured parliament. So there are some independents who are running for election, and I see that as real opportunity, because they are people who would see this as a first instance issue for reform in Australia. And I think we're moving into a period of opportunity. That's what I'm trying to say.
with this glimpse of optimism, I think it's time to bring this discussion into an end. Please join me in congratulating and thanking our two brilliant speakers, Professor Mary Crock from the University of Sydney and Rasika Jayasuriya from UNICEF, for coming and speaking with us today and sharing their experience and expertise. Thank you very much for Andrew Felkovich and Claire Sidotti from the DTP for making this webinar existing and available and for producing it. Later today, you'll get an email with all the links that you shared and information that we have shared with you today, and with some details about our next webinar that will be held in either late May or early June. So watch your inbox. Thank you very much for joining us today and have a good evening.
Thank you. Thanks.
Thank you.